welcome to another episode of Litigators Corner, and I am privileged and proud to have here with me my colleague Alexander Rufus-Isaacs, who sits on the board on the litigation committee with me. And Alexander had the distinct pleasure of being involved in the Johnny Depp libel matter that was across the pond, and we just received a verdict. And Alexander, thank you so much for coming today.
Hillary, thank you very much for asking me. It occurred to me this morning that you and I have become pretty good friends over the last 6 months. We've done a lot of litigation committee together and we've talked generally, but we've never met in person. Isn't it a strange age we live in?
It really is. I know I'm getting that a lot. Like, hey, I'd like to meet you someday. And normally you come over and have lunch or, go have a drink after work or something like that. But in this day and age, we have to do everything virtually.
Well, maybe we can play soccer one day together.
That would be fun. You're the goalie. I'll shoot at you.
Hillary is a former professional soccer player, everybody, so I find that as a lifelong soccer fan, I'm very impressed by that.
Thank you. It's always nice to be appreciated. Alexander, tell us briefly about yourself and what you do.
Well, I was born and brought up in England. I was admitted to the bar in England and practiced as a barrister from 1982 to 1987. And for various reasons that are still unclear to me, at the end of 1987, I moved to California. I took the February 88 bar and managed to get through. And I've basically been litigator in Los Angeles ever since. I'm still I'm still licensed in England. But I don't practice. I think it's pretty much an impossibility to master the intricacies of both systems. But I spend a lot of time in England. I travel there. I have a house there. And when I'm over there. I'm in London meeting with the London law firms, and I have lots of friends there. And have some good and enjoyable relationships. Also, through the Beverly Hills Bar, I was chair of the entertainment law section and developed a London chapter because we felt that entertainment was an area where people all around the world would be interested in hearing the content of the kind of speakers we put on here. And it's proved to be the case. And we've had some very successful sessions when we've had sort of eminent California entertainment lawyers in London. They've been hosted by one of the London law firms. And it's an interesting way that world is shrinking in many, many ways, and that's an example of it.
It is, and it sounds like you've managed to make it a very productive and fulfilling way for people to stay in touch and do business and maybe connect with people that you wouldn't otherwise meet. So, Alexander, you were involved with the Johnny Depp libel matter in the UK, and I think we are all fascinated by this. I know I've read part of the judge's opinion. I believe it was a 128 or 129 page opinion. Is that about right?
Yep.
Tell us about your involvement to the extent you can and your experiences with it. I think we're all excited to hear about this.
One of my good friends in London is Louis Charalambous. Louis is a partner at the law firm of Simons Muirhead. And he's a particularly accomplished media litigator. But Louis, in any event, has been representing News Group, who published The Sun and other newspapers for a number of years, and I've helped him out from time to time. And probably about a year ago, he rang me up, and he was in town with a colleague of his called Jeff Smeal, and we had dinner, and that was the first time I heard in detail about the case of Johnny Depp versus News Group newspapers and Dan Wootton. And at that stage, I think we were due to go to trial in April, and must have been in around January or February, Louis contacted me and said that they were going to need some help in Los Angeles and would it be available, and I said of course I would. And there were two areas in which they needed help. One was to set up a video conferencing facility because of the very large number of witnesses that were going to be called in the High Court in London who were resident in Los Angeles. And to avoid them all having to travel, it would be much more convenient, obviously, if we could set up a reliable video conferencing facility. So I immediately thought, of the Beverly Hills Bar Association, because I've used the Bar Association's offices on numerous occasions to do video depots. So they have some great technology, and rather than having to travel to remote places around the US, I've found that so long as one has a very large screen, so you get a very good view of the room on the other end, it's a very effective and particularly cost-effective way of conducting oneself. So I made inquiries with the Beverly Hills Bar, and they indeed turned out to be the host. There was also my other function in this was to get orders under 28 U.S.C. 1782, which is pretty much akin to a subpoena, to require residents of Los Angeles, well, residents of wherever the court is, but in this case, residents of Los Angeles, to appear and give testimony in a foreign proceeding. And the application can be made by any interested party, and particularly any party to the foreign proceeding. So we fit the parameters pretty well. And, you know, the cases involved, as I said, a lot of witnesses. I mean, at the end of the day, it really came down to the defense raised by News Group to the main allegations made by Mr. Depp. You know, let me give a little bit of background here on the case. In April of 2018, The Sun published an article in which it expressed surprise that Johnny Depp, who was described as a wife beater in the headline of the article, had been cast in Fantastic Beasts, and expressed surprise that J.K. Rowling, the author, was okay with that. News Group defended the lawsuit, and it ended up that Mr. Depp filed the lawsuit in the High Court in London. He also had another lawsuit, which he filed, I think, later in Virginia against Miss Hurt, who was his ex-wife. And the allegations were, in both cases, he said he'd been libeled by being called a wife beater. News Group raised the defense of truth. And that's one of the differences between the English system and the US system, is that in the US, the burden is on the plaintiff to prove on balance of probabilities that the statement in question, which they claim to be false, is indeed false. Whereas under the English system, truth of the defense that can be raised by the defense, and they have their burden in those circumstances is they have to show it by substantial evidence, which sounds like it's a bit higher than on the balance of probabilities. So that was the battleground in this case, is could the Sun establish with substantial probability that Mr. Depp was indeed a wife beater? And witnesses were lined up on both sides. And a number of them, particularly those here in Los Angeles, two in particular, were reluctant to attend. And that's why I was asked to obtain 1782 orders, and I went ahead and filed them.
And how many witnesses were there for this hearing? I didn't know about the change of the balance of probabilities and really a shifting of the burden of proof in the two different systems. So just so I'm clear, if you make out a prima facie case in your pleadings, the burden shifts to the defense if you assert a defense of truth?
Well, in England, you don't have, as a plaintiff in a libel case, you don't have to prove that the statement is false. You just have to prove that you were damaged by it.
And how many witnesses came through the doors in the Bar Association for this trial?
Around 20.
Wow.
We had, and because of the time difference, the time difference was that the judge in the case in London, Mr. Justice Nichol, who is a very accomplished media judge, had written the treatise on media law in England before he became a judge. was willing to accept testimony by video, especially when, the pandemic hit. And the afternoon session in London would start at 2 p.m. local time, which would be 6 a.m. Los Angeles time. And so we were basically aiming for the LA witnesses to testify going from 6 a.m. to 9 a.m. On one occasion, when I luckily was not present, they scheduled some witnesses for the morning session, which was 9 a.m. in London, 1 a.m. in Los Angeles time.
Oh.
So those folks didn't get much sleep that night, but I guess they preferred to do that rather than get on a plane to England.
Yeah, or coming into the building with sunglasses.
Yep.
It's what was the feeling you had just of the atmosphere? I was curious if that's something you can speak to. Just did you get a feeling of the mood or the atmosphere when you were watching these witnesses testify?
Yes, I mean, obviously though it was a libel trial, what was another interesting facet of it was that the Queen's Counsel, in the English system, the Queen's Counsel are the most senior barristers who conduct trials. The QCs on both sides were criminal QCs. They were assisted by QCs who specialized in libel. The news group was originally brought in Sasha Wass, who is a very accomplished criminal QC, because obviously they felt that, that skill set was required because there really wasn't very much law here. If it called somebody a wife beater, if it's false, it's pretty obviously libelous. And so it really came down to a sort of, one person's version of events against the other person's version of events.
And how many days of testimony were there for this?
15.
15 days of testimony.
15 solid days of testimony. I think maybe with a little bit of some openings, and maybe a closing, but they were quite limited because it's a bench trial. Right. In the English system, we kept jury trials in libel cases for longer than we did in other civil cases, but now that's gone, and so these are all bench trials, and as a result, they obviously go much quicker.
So it's pretty much the judge's call on whether they believe that comes to a credibility issue?
Yes, and I mean, if you take the time, as you've read some of it, it's an incredibly detailed ruling, and the judge follows the testimony. He follows the testimony of each of the witnesses. He makes findings in many cases as to whether or not he finds a witness to be credible or not. And, he takes one through it. The Sun basically, or actually News Group, alleged 14 specific instances where Mr. Depp had beaten Miss Heard. And so we were arguing, the witnesses were, talking about one aspect or another of those 14 instances. And also there was some general issues as well that were raised by Mr. Depp as to whether Miss Heard was credible because of some allegations that she'd lied about bringing her dogs into Australia. Mm-hmm. But it was really about, these very painful experiences, between this couple as their relationship was disintegrating. And, it was that you asked what the mood of the court was. I think there's an element of sadness about it, is that a couple who obviously at one time were very much in love, that their relationship has disintegrated to the extent it had. And, most of the witnesses really didn't want to be involved. I mean, they were loyal, they were a friend of one or other side, and they wanted to support their friend. But at the same time, there's a considerable reluctance to get involved in these things, and particularly where one has celebrities. Some of the witnesses, one in particular, one of the ones against whom I had to get a 1782 order, said, she's a makeup artist, and she said, I don't want to be part of this because I have celebrity clients, and if they see that I'm there giving evidence, they're going to, perhaps not use me again. In fact, she had no option. She was, we got an order and she had to comply with it. But, one can understand how that works. And, you know, it's generally, it's a sort of a distressing sort of atmosphere to the whole thing, I think.
Was the judge interactive? And I, forgive me, I don't know much about English law other than what, out of my own interest, I've read. You know, some judges will be more interactive when they see a line of questioning, particularly in a bench trial. They'll start to ask questions. They'll say, "Wait, I want to talk. I want to hear this. Answer this for me." Was the judge in this case interactive or proactive like that, or was he just listening, or what were your observations?
My experience was, I think he struck a very good balance of letting, two very well qualified barristers, who have spent their entire life cross-examining witnesses, or professional life, I should say, cross-examining witnesses, get on with their job. And by and large, I think they did an excellent job. He did on occasion have additional questions, and, he managed the proceedings very well. He was observing strict time limits. He was, chivying the barristers to perhaps, hurry up. And so, otherwise it could easily have gone on for another couple of weeks if you hadn't had a judge who was so keen to fit it in. The other thing is that this was an exceptional case to go to trial, just, as I say, as an exception to the general rule that most trials would put off. But I think there's the perception that, particularly in libel cases, people's reputations are of such importance that, they need to make a decision one way or the other. And obviously, as a result of the decision, there have been some, repercussions already, particularly for Mr. Depp, who has lost the role in Fantastic Beasts. But, that's why this case was fast-tracked in London and given priority over a lot of other cases, which was the subject of some comment and criticism, it must be said.
Because they gave celebrities priority over everyone else whose reputations or had other issues that needed to be adjudicated.
I don't know if there was a certain perception of that, these are celebrities, so they get preferential treatment. I don't know if it had been a libel case between two non-celebrities, whether it would have been treated the same.
I think that's certainly true. And do you have any interesting insights as to things you saw during the trial that you feel comfortable sharing, or things you found entertaining that are not confidential or that can be discussed? I'm liking this look.
Well, I think what came through for me was, and the judge picked up on this, is that Mr. Depp was struggling with alcohol and addiction issues. And I think that came through quite strongly. Some of his emails to his celebrity friends were introduced into the trial. And for me, at any rate, and I don't want to get too personal, I felt that this was a man who was, struggling to stay sober and whatever else he might be like in his life. Someone who's a active addict or alcoholic is going to act out one way or another.
Yeah,
and,
I do.
That was the sort of subtext, the whole thing. There were constant references by Ms. Heard and also by Mr. Depp himself to, quotes, the monster. Is that, I often think that alcoholism and addiction are sort of almost a sort of bipolar condition, is that people can be, great normal people, but when they get wasted and when they're in active addiction, it's a disaster. And I felt that this was very much the sort of subtext here, is that, when he was, loaded, it seemed to be that when, these incidents occurred, and, that in itself gave a tremendous amount of credibility to, what happened.
And that's not unusual in other matters. I've worked with some with celebrities, some not. If there's an issue of substance abuse or addiction, you often hear the reference to the monster, the animal, the demon. That's very common. I did note in some of the opinion there was commentary or analysis by His Honor, if that's the correct way to address him, that did actually refer to that and say that his cognitive abilities or his memory may have been impaired because of these instances of that. So his perception or memory or recollection of these events may not be accurate, not because he's not telling the truth as he remembers it at the time of the trial, but his recollection is so faulty because of that, that he can't give accurate testimony.
I think that's correct. I think, you know, he's probably in blackout during a lot of this.
And which is always an unfortunate and sad situation.
Yeah, it is.
It's in reading the opinion, there are a lot, not just, I know there are differences between how they do things in the UK and how they do things here in our systems, and people speak differently and have different customs. But I like to think in certain ways people are the same and can all learn from each other. What lessons do you think we can learn from the Johnny Depp libel matter? I just think that the opinion itself was fascinating. How well reasoned. I mean, obviously, this is a very brilliant person who is, you know, very, very up on all of this areas of the law, and we can all learn from him. But what do you think we learned from this ruling, and how for everyday people and for other celebrities?
I think the message is avoid costs, avoid court at all cost. I feel that Mr. Depp was probably very badly advised to bring this lawsuit. You know, had he not done so, had he avoided also bringing the suit in Virginia, I think possibly these allegations would have, you know, remained in the consciousness, but in the more remote parts of the public consciousness. Whereas what he's done here is just springboarded them right into everybody's face. And, you know, given the, you know, strength of the evidence against him that Ms. Heard managed to put together, either he was not told that you must realize that the following people are almost certainly going to give evidence against you at, you know, these assaults did take place, A, B, C, D, and E, and how are you going to feel? And there's always a risk that, you know, the verdict's going to go against you. It is no, you know, foregone conclusion, this. And, you know, I think wiser heads should have prevailed, and he should not, obviously, easy to Monday morning quarterback it, but clearly, you know, this has been a disaster for him.
No, I think so. And I've spoken to a lot of people, not only in our profession, but privately, who are saddened by it because they are fans of Mr. Depp, and to see this, yeah, like his work and have enjoyed it for years, and to see this come out. And I think there is that question, why did you bring the suit? Why did you bring this to everybody's attention? It's
the other thing I would throw in as well is I have considered, without, you know, personally taking sides on this, I feel very much for Ms. Heard, who has been absolutely vilified and attacked by, you know, the pro-Depp, you know, elements, and really castigated and abused in a really horrible manner. And, you know, she, you know, clearly, she's obviously been vindicated, and by what's happened. But again, this was, I imagine, without talking out of school, this probably, and I have no personal knowledge of it, that this has probably been a very trying experience for her as well.
I'm sure to go through that was very traumatic for her. However, I mean, we don't know because we weren't there, but, you know, what happened, you know, just even getting a divorce can be traumatic. And if these allegations are true, are certainly traumatic. And then to go through it again and feel like you're being victimized again. So I really admired it. I understand that she was very composed, and she did really a remarkable job of maintaining herself and presenting what she needed to do. So
I think it's very brave.
Yeah.
And I think a lot of the witnesses, and I think of a couple, particularly the ones that, you know, testified at the Beverly Hills Bar, the method of cross-examination in England is different. If you tried to conduct an English cross-examination in a US court, you would get constant objection of badgering the witness. Isn't that the main thing? I don't know why badgers get such a bad deal. English barristers are allowed to be much rougher on cross-examination. And, you know, they are out and out, you know, accusing the witness whom they're cross-examination of lying, time and time and time again. And, you know, it's that very interesting process that, you know, the purpose of a trial is really to get to the truth of the matter. And, you know, we've all seen instances of how when a witness goes into the witness box, somehow the layers of the onion get peeled back a little bit. And obviously there are some very accomplished liars out there, but one, I think, gets a better idea of whether or not somebody's been truthful when they've been through an experience like that. And, some people, it becomes very obvious that they're lying. Other people, you see that they're being very brave and continuing. And, it's a very interesting, experience. It's not pleasant for those who are going through it. But, particularly one of the witnesses who I got a 1782 order against, who was the makeup artist, she was really being hammered by opposing counsel, by Mr. Depp's counsel. I'm not saying, in any way that's not permitted under the English rules, but it was pretty fierce. And she really stood up to him and stood her ground. Mm-hmm. What was interesting was that the other witness I got a 1782 order against was actually somebody who'd given a declaration to one of Mr. Depp's lawyers in his favor. Mm-hmm. But she subsequently had a telephone conversation with Miss Heard, which was recorded, and there's a dispute as to whether it was recorded with or without her consent. But in any event, it was admissible. And in that tape-recorded conversation, she said completely the opposite and said that she had been pressured by Depp's lawyer to give this statement, and it was all crap. And basically, she was very apologetic, and so we were very keen when, after he had listed her as one of his witnesses, to bring her in and put those allegations to her, which Ms. Sasha Wass did very well. Because here's another interesting difference between the two systems. The English system is all about preparing witness statements. Mm-hmm. Now, a witness statement is very much like a examination in chief. It's a written examination in chief. It's basically the witness's story. And both sides, in the pretrial conferences will exchange their witness statements, and they can simply proffer the witness statement in lieu of a live witness. And that's indeed what Mr. Depp's lawyers wanted to do. They just wanted to introduce this statement that had been obtained from this witness. But we said, no, we need to cross-examine her and put to her the statements she made in this telephone conversation with Miss Heard. And sure enough, Mr. Justice Nicol found that she was not the most reliable of witnesses, shall we say. So, and basically discounted her testimony. So that neutralized this, very problematic declaration that she'd given to Depp.
And does these statements, do they observe hearsay rules, or do they, I know the rules of evidence must be different. And I know that's a general question, but it just, from what you're describing, it sounds like maybe from what Americans may consider, they're like, there's no way this is going to be admitted. They include information, or U.S. statements too.
I'm constantly staggered, and I, without revealing anything, many of my conversations with Louis and with Jeff in London were, how does this hearsay rule again work? Because they seem to be able to put matters in front of the court in England, which are simply, would not be allowed here. These declarations, where the other side has had no opportunity to examine the witness. It's like putting a declaration in lieu of a live witness, whereas, and they frown on depositions where, obviously both sides have had a chance to question the witness. And I still don't understand why they prefer these witness statements. I think it's purely perhaps a mechanism just to move the case along and save time and not all have these pesky people asking questions. But, the English tradition is very much one of oral advocacy. The emphasis, despite the witness statements, as a young barrister, I was in court every day from the age of 23 or 24. And the guys who've been doing it, 20 or 30 years, you get pretty good at it. They know how to ask a question. They know when to shut up. They know when to sit down, all of those sort of things. They really know how to talk to a jury.
Sometimes when we have rulings, judges out and out say it. Other times they're telegraphing things that they're saying to the public and to other attorneys and any other litigator who comes in. If you come into my court, this is what I'm expecting you to do. Do you think there was any of that in the ruling from the judge there, other than the clear statements that the
I think, judging from what I heard from my colleagues in London, he kept his cards very close to his chest. And apart from the fact that he wanted people to get a move on and, you know, gave time limits, I think otherwise, no, he was, it goes without saying that you've got to be prepped and ready to go, and, you know, when the whistle goes.
do you think it's fair to say this is a trial you always remember?
Oh, yeah, certainly. And, you know, it's so strange to be doing it remotely, you know, because we were sitting there in the room at the Beverly Hills Bar where I've sat through innumerable board meetings and MCLE presentations and everything else. And it's full of these sort of strange people. And there is this huge screen, which was maybe 10 foot by 12 foot. And on that screen, you could see the whole of the courtroom in the Royal Courts of Justice on the Strand in London, which I know very well. And you could see the whole courtroom there. And, you know, one was conversing as if, you know, they were in the next door room. And it was, I think it was a very good experience from the point of view. It saved a tremendous amount of time and stress and aggravation for people because they didn't have to travel. I think it's very efficient. You've got the right technology, and the technology worked absolutely beautifully. And so I think it's another way in which this terrible, you know, pandemic that we live in has some upsides, is that it makes us kind of think of doing things differently. And I think this is something that one should have done even if, you know, there hadn't been a pandemic with all the lockdown and other problems involved, because it's efficient and, you know, it's very effective.
And that's always a matter of people. These days, people travel all the time. It's not unusual. Such and such moved to New York, or such and such moved to Miami, or such and such moved to Colorado. So and often it is a problem to get witnesses in the courtroom. And maybe this is a solution for a lot of people to do that. Was the press? I'm assuming the press was kept out of the courtroom.
The press was not present at the Beverly Hills Bar. There were 5 courtrooms in London. Dedicated to this trial. I think the press had 2 of them. So they had video feeds from one courtroom into the other 4.
And so did they have an artist in the courtroom, or they were live in the courtroom just by video?
I'm not sure.
Were there people, and how many people were in the courtroom, and did they observe social distancing? I'm just out of curiosity.
Yeah, they were observing. That's why one had to have so many courtrooms, is because, you know, everybody was sitting a long distance apart. I mean, I was looking at the courtroom, and maybe there was, you know, normally you could fit maybe 40 or more people, and there were maybe 50, you know, with everybody well spaced out. And that said, I must also say is that the 2 witnesses who, you know, I had to get the 1782 orders against were both very concerned about having to come to the Beverly Hills Bar Association to testify, you know, because this was in July when we were still under pretty extreme lockdown. I mean, they were just loosening up, you know, you can go into some retail establishments, but, you know, it was pretty tough. You know, so we had to be very careful at the Beverly Hills Bar of making sure that we did everything we possibly could to ensure the safety of the witnesses. And, you know, we had a cleaning service came in, and they were there present during the whole trial. So every time a witness left, the cleaners would come in and, you know, disinfect the whole area where they'd been sitting. We had a range of about 10 big 3-ring binders as well for the exhibits, so they had to be disinfected. Even despite everything else in this world, we still like our 3-ring binders, and I'm very much.
We do like
several sitting right here in front of me. You know, is that there's no substitute for, you know, having a piece of old paper to rustle.
The notepad and the pen is something that makes you feel a little more comfortable.
Yeah, but at the end of the day, my position to these, you know, to the judges and the 1782 orders is, you know, nothing is risk-free, but, you know, this is safer than going to Ralph's.
That's certainly true. What would you tell our viewers about things you would want them to remember about this trial, and things you would want them for lessons learned, so to speak?
I think what I said earlier is really, I think the main lesson to be learned is that, you know, do not bring a libel action unless, you know, you are very, very sure of your position, because it will focus attention on allegations that might otherwise have slipped away through the passage of time. And if you lose, circumstances are going to be very serious.
Okay. How common are appeals in the UK?
Well, appeals are very common, but there are really no points of law in Mr. Justice Nichols' decision, or at least very few, or nothing really to argue about. It was such a fact-based decision that, I can't see how any court of appeal would reverse him. The English courts of appeal, like the courts of appeal here, is they tend to leave issues of fact-finding and credibility to the trial judge, and they're really only interested in any apparent errors of law, and I certainly couldn't see any. From a PR point of view, of course, we're going to appeal this outrageous verdict, but when you sit down in the cold light of day and going, what are the grounds for the appeal? I think they're going to be, have to be, I don't see any.
Well, Alexander, this has been such a lovely and fascinating interview. I have so looked forward, and you did not disappoint. I am sure that all of our viewers are going to appreciate and enjoy this presentation.
You mean there are people watching this?
There are people, not just us. Glenda was on earlier.
Thanks, everybody, for tuning in. It's been great. Hilary, thank you very much for,
Thank you. Thank you
putting
for
this on, for asking me, and for being a great moderator.
Thank you.